In an interesting case from Mississippi, the plaintiffs, Clarence Cocroft and True Source Medical Cannabis LLC, challenged Mississippi's restrictions on advertising medical marijuana.
This is Dr. David Schein, and welcome to Business Law 101.
Their legal argument was that the First Amendment protected their right to advertise because the state permits the underlying commercial transactions. The plaintiffs sought declaratory and injunctive relief against the state officials in their official capacities. The United States District Court for the Northern District of Mississippi dismissed the case under Federal Rule of Civil Procedure 12b-6. That's a summary judgment, says you don't have a case, get out of court. The court applied the Central Hudson test for commercial speech and held that because federal law criminalizes marijuana, including medical marijuana, the advertising of such transactions do not qualify for First Amendment protection. The Central Hudson test was put forward by the Supreme Court in the 1980s and established the standard that generally governs government restrictions on commercial speech. The court explained that commercial speech enjoys lesser protection than other constitutionally guaranteed expression. The First Amendment protection for commercial speech is based on the informational function of the advertising. The court said that there can be no constitutional objection to the suppression of commercial messages that do not accurately inform the public about a lawful activity. Note that the next to the last word is lawful. As noted, marijuana is not legal at the federal level. The plaintiffs appealed the district court ruling. The United States Court of Appeal for the Fifth Circuit reviewed the case. The appeals court affirmed the district court's dismissal, holding that under the Central Hudson test, commercial speech must concern lawful activity to receive First Amendment protection. Since the Federal Controlled Substances Act prohibits marijuana nationwide, including in Mississippi, the underlying commercial conduct is illegal. Therefore, the state faces no constitutional obstacle to restricting commercial speech related to unlawful transactions. This is Dr. David D. Schein for Business Law 101. If you've enjoyed this episode, please subscribe on your favorite platform.